The Constitution of India contains provisions which allow for the amendment of the Constitution. Those amendment processes seek to strike a balance. A constitution should be stable and enduring, but not so rigid that it cannot be changed in the interests of the nation. Those provisions are contained in section 368 of the Constitution. Amendments must be passed by a special majority in each House of the Parliament, and in some cases also by the parliaments of at least one half of the states of India. Part 3 of the Constitution of India sets out the fundamental rights of all citizens of India. Until 1979, one of these rights was the right to acquire, hold, and dispose of property. Now, in the period after independence, many states established laws which limited the maximum amount of land which could be owned by an individual farmer. When Henry Golak Nath died in 1953, the state of Punjab declared more than 400 acres of his land to be surplus land, and they compulsorily acquired the land without compensation. His children, who lost the opportunity to inherit the land, sued, arguing that this law interfered with their right to acquire, hold, and dispose of property. Now, they were not the only family in this situation. The National Parliament, trying to find a legal solution, passed the 17th Amendment to the Indian Constitution, which specifically made the Punjabi legislation valid. The question before the Supreme Court was whether the Parliament could actually do this. It is clear from Article 13.3 of the Constitution that the Parliament cannot make a law that breaches fundamental rights. The question, though, was whether a constitutional amendment was law. It's clear that the Parliament cannot make laws which breach fundamental rights, but can the Parliament amend the Constitution in a way that breaches fundamental rights? The Supreme Court said no. The majority judges said, "We declare that the Parliament will have no power from the date of this decision to amend any of the provisions of Part 3 of the Constitution so as to take away or abridge the fundamental rights enshrined therein." Many aspects of the law and the Constitution have changed since this decision, and it should be relied on with the greatest caution. But it did establish the important principle that Parliament must be respectful of the fundamental rights granted to all Indians under the Constitution.